Hello and welcome back to the Argyle Cybersecurity Solutions CISO Summit. My name is Vicki Lynn Brunskill with Argyle. It's great to have everyone joining us today. Just a couple of notes before I turn things over to our esteemed speaker for this keynote session. First, a quick reminder to stop by our sponsors' virtual booth at any time during today's event and for the following week. Lots of good stuff there, including complimentary materials, information, meet and greet opportunities. Also, to ask questions throughout the session, simply type into the Q&A chat and we will address your questions at the end of the session. And if Scott sees something he'd like to answer in real time, he will do so. And now, without further delay, I'd like to introduce our speaker, Scott T. Lashway, partner, co-leader, privacy and data security practice at Manette. We are so excited to have Scott with us for a keynote presentation titled Privacy and Data Security, Technology, Trends, and Regulations. Welcome, Scott, and over to you.
Thank you, Vicki Lynn, and good morning, good afternoon, good evening, wherever you are. I have the pleasure of giving you about 25 minutes on an update from what we see in our practice. I'm a lawyer who's been working both in the privacy and security space for about 20 years now. Obviously, there's a lot of conversation happening globally around the use or misuse or alleged use and misuse of data and the infrastructure that organizations use to collect and transmit and store that data. But the problems start not just with what's happening outside of the organizations. They often start with what's happening inside the organizations and your reactions to all those inputs that we're learning from this news feed or that news feed or this regulator or that regulator. And we'll talk a little bit about some of those today and how you can practically respond and continue to prepare yourself on a daily basis. We have a little saying in our practice with our clients that you can't necessarily control all of the inbound risk in privacy and security, but you can absolutely control all of your reaction to it. And it's that reaction to this never-ending treadmill that we're on over the last 10, 15, 20 years that has caused a lot of the problems that we read about in the papers. And proper reactions to that risk help prevent us having to read more about some of these problems. I think a lot of you probably pay attention to CISA, which is part of the government in their cybersecurity mandate coming out of the White House. And the director Easterly recently gave a speech at Carnegie Mellon in which she was talking about the spy balloon, which at the time was the focus of headlines globally. And she said that the risk introduced to all of us by unsafe technology is frankly much more dangerous and pervasive than the spy balloon. Yet we've somehow allowed ourselves to accept it as we've integrated technology into every facet of our lives. We've unwittingly come to accept as normal that such technology is dangerous by design. And so here we are having to cope with that in your roles and in mine on a daily basis. We know that the threat is real, but the threat doesn't always come from the places where we most expect. So there's a lot of attention paid to things like insider threats, and that's all for very good reason. We'll talk about some of that. But they also come from places that we can't accommodate or contemplate in advance. So the Log4j vulnerability was an easy example of that, where most organizations, most CIOs or CISOs, or those who are responsible for the technical infrastructure of the organization, have their hands full every day meeting the business needs and the strategic needs of their company's endeavors. And you don't always have the capacity to anticipate whether a vulnerability may or may not reside in one of the applications that you're relying on, either on the periphery or at the core of your operations. Yet when the vulnerability is detected and announced, either through a CVE or some other alert, like a CISA alert, it's kind of an all hands on deck, whether that be a Friday before a 3-day weekend or something else that you're about to do, like close your company's quarterly financials. We get a lot of questions these days about migrating to the cloud and whether or not it's safe and whether or not it's something we would recommend. And as lawyers, we're often focused on what are you using the cloud for, and we're working with CISOs to understand whether they can protect the cloud instance that's going to be used, and how is it going to be used, and where it's going to be located in the world for purposes of moving data around. And that's really focused on sometimes the privacy aspects. Of course, who has access to that cloud, and is the access secure? Are we prepared to live without the cloud? Should there be connectivity issues or other vulnerabilities that are exposed? Are all questions we like to ask as lawyers. And you all should be asking as CISOs or folks involved in that community as well. There's obviously risk categories that come up routinely from a legal perspective in our interactions with the CISO. Most importantly, we focus on protecting the infrastructure. And I'll talk a little bit about in a minute about how the US in particular is going about regulating data from a privacy perspective. But there's a lot more focus these days on regulating data from a security perspective. And that focus is both through the lens of organizations like CISA and other parts of the government, depending on how you're regulated, but also through the lens of the private plaintiffs bar and courts, where we see repeatedly now security cases that are not just focused on the theft of, say, credit cards or other big data breaches, but the inadvertent transmission or the purposeful transmission of data to organizations outside your company, which many believe, at least on the plaintiff side of the bar, can violate one statute or another. The most recent wave and the feeding frenzies are on the wiretapping statutes related to analytics on your websites. And so while you're at home Monday through Friday, and then on the weekends, making sure that your infrastructure is safe, the plaintiff's bar develops a new form of data breach related to the operation of your website and the collection of information through things as simple as cookies and pixels, things that are necessary to operate your website and make it useful for the user. And now you've got a security vulnerability or a security litigation that intersects with data privacy, data handling squarely on your plate. In short, it's really hard to keep track of all of the bad people and bad motives. Now, this is a well-worn slide, and it hasn't changed much over the years. So I've been using this slide now for close to 10 years, and it really hasn't changed. There's been different focuses, right? So for a long time, we were focused on credit card theft. That problem has been somewhat solved for, or at least mitigated, with new forms of encryption, third parties handling card transactions as opposed to each organization having to build their own programs. But we're also now focused, I think, maybe back again on things like defamation in the press and policy, and access and propagation of malware of various forms. The number of phishing events that result not in necessarily the harvesting of intellectual property or confidential data, but the use of that mailbox to propagate another spam exercise to further invade additional victims is rampant and nonstop. And trying to sort out the motive of those actors in a chart like this can be very, very difficult and sometimes nearly impossible. And so when your board of directors says, well, what's the greatest risk of the organization? You could turn to a chart like this and say, well, it's all of these, but it's also the insider threat, which is the missing category here, or a missing category, because it only takes one employee who's not paying close enough attention to mistakenly click on a link that can have cascading impact on the entity, certainly on that employee. I think one of the problems we all face right now is relative to that threat landscape and the various vectors that those actors operate within. There is a constant stream of data coming at us about how the threat is real. And this highlights a couple of the different reports that you all probably pay attention to. You may even use when you're asked to report up to the board or to the C-suite. which I hope you're doing on a regular basis these days. The challenge, of course, is trying to ensure that those individuals understand that this threat is not theoretical for your organization, and that they also understand that you as a single person, or even with the largest CISO budget out there with a huge team, have nearly an impossible task of preventing the what if or the when. Now, I don't subscribe to this idea that, at least from a legal perspective, we should all say, well, it's not a matter of if, it's a matter of when. That is not me. I also don't subscribe to this idea that's been bandied about for years that all organizations have been compromised at some point. But I do think it's important for you all, and certainly it's required under some states like the New York Department of Financial Services cyber regulation, to be reporting both on the threat landscape outside the organization, as well as the threat landscape within the organization. So what that includes is data. Some of this is here. Here's another one that is widely read from CrowdStrike, where you're setting the stage for the environment in which you operate. Now, to be very clear, this is an environment in which you operate regardless of what you do, the size of the organization, your revenue. There's a misconception by executives that we're not that important because we don't have a lot of intellectual property. We're not that important because no one could ever replicate our business model, or we don't have a lot of cash on hand for theft. We don't wire a lot of money that could be interrupted through a business email compromise. There's all these things that they read about, and they're gross misconceptions as to whether you could be targeted. We've seen sophisticated threat actors target small mom and pop shops, target, a 5-person accounting firm in a Midwestern farming town, all the way through, defense contractors, healthcare institutions, and healthcare provider organizations, you name it. There's no organization that's immune to this. And then how do you deal with it? So here's a couple of examples if you want to use on your internal reporting where, these are actual phishing emails, and here's a smishing that I received myself. And we've seen these types of things evolve over time. They're far better than they were just a few years ago, and they're very difficult to detect if the user is not paying attention. Here's another one that you can use where you can imagine your employees becoming victimized by this, and then the cascade of effect. And the problem is often the interconnectivity of your organizations that's demanded. And so this is all not news to you, but this is all coming from the legal side of the house. All of these items create massive amount of legal risk, in addition to the risk that you might be focused on, operational risk, technology risk, business continuity. We often are now turning to cloud providers. And this isn't just, the big data storage places like the Azure and the Azure and the Amazon and the Googles of the world. This is almost every application out there that's either relying on their own cloud or relying on one of those. We can obviously control our own connectivity to that cloud by careful oversight and making sure we have the expertise and the thought processes while we're implementing it. But we can't always control that when it comes to our vendors. And the amount of work that is involved in onboarding a vendor who's connecting to the cloud or allowing you to connect to the cloud through them is remarkable. We're far beyond the days of using a typical, standardized diligence. Do you have your SOC 2? Great, you must be good. When organizations are relying on third parties to provide technology services, whether it handles data or not, the burden on you these days is extraordinary to ensure that that organization is going to live up to your expectations. Now, all of those organizations have lawyers like me and CISOs like you telling them, well, we can't really tell them everything we do because then that would compromise our security. But a trained eye can see gaps in that diligence process to at least raise questions that need to be probed. This all frustrates, of course, the business owner who wants to move more rapidly on the new product development, but they will ultimately thank you or not when you don't have this risk materialize down the road. Yeah, so let me get to that. I've got a couple of questions here, and let me get to one of them right now. So here are origins of cyber legal risk. This is not exclusive. Let me give you an example. Here's the federal and state wiretap laws, and I've spoken about that. There are literally at times dozens of lawsuits filed daily in the form of class actions around the country, focused on the use of pixels and cookies to collect website traffic data, either in front of a paywall or behind a paywall. And the defenses and the legal analysis between those two things can vary greatly. But these are all things that you as a CISO can make sure your marketing team, your website team, or if it's you that's responsible for, is paying attention to. There are easy get out of jail free cards with respect to compliance with wiretap laws, like consent, like ensuring that the individual knows what we're collecting and how we're collecting it and what we're doing with it. These are things that we put into privacy policies in terms of use. And at least you'll have an argument down the road to get yourself out of the trouble that a plaintiff's lawyer could gin up. There's a lot of biometric litigation right now with respect to the handling of, say, a fingerprint technology for fingerprint scans for employees. And the Illinois BIPA cases are extraordinary, with the Supreme Court in Illinois speaking repeatedly over the last handful of weeks about the extent of potential harm and damages available. And so the cases there are only going to increase. Now, one of the questions I had is there a website to know different cyber laws for each state? California is so different than New York, especially for biometrics laws. So California is different than New York. The CCPA contemplates biometric information to the extent it relates to an individual or can be used to identify an individual would fall within the California privacy law. Illinois has the leading biometric law on the books along with Texas, but Illinois gets the most frequent attention. There is no website that we turn to that catalogs all of these laws. Many of them are old. The wiretap acts come sometimes out of the 60s, and then they were revisited in the 80s. Computer Fraud and Abuse Act comes out of the 80s and was focused on Cold War espionage. And some of them are new, like the California privacy law and the privacy laws in Virginia and Utah and Colorado and Connecticut. We anticipate as many as another dozen of those laws coming on the books in various states in the next 24, 36 months, with about 13 bills being actively attended to right now in state houses around the country, including Massachusetts and New York. Florida is another one. You can't divide where those laws are going to be developed between red states and blue states. It has crossed the political aisle, for example, even though in Washington, they still can't seem to get a privacy law in the books. Now, why does this matter? Because a lot of regulators are looking to regulate cybersecurity through privacy. And we'll talk in a minute about this with respect to the handling of employment data. But first, this is an example of why there isn't a single website that can speak to all of these laws on the books. So this is a slide highlighting a case related to Marriott that's gotten a lot of attention by some of us. And this was related to an attack on Marriott in which they were victimized, allegedly. The court in Delaware that we often turn to for things like corporate governance speaks to the fact that the organization, if you're a Delaware organization, but everyone looks to Delaware, would have obligations to handle and implement reporting systems and controls to monitor the risks. That is where you as a CISO are at the front lines of this risk. And what I mean by corporate governance are things like negligence here at the top with a common law claim, and fiduciary duty at the bottom. Standards under the law which require organizations and certain of their employees or board members to operate, to handle with care the organization's assets. Delaware spoke again, this time outside the context of cyber recently, and opined that not only do the chiefs at an organization have these obligations and oversight responsibilities, but officers have that as well. So when you think about your title and what that O means at the end, you need to be very attentive to whether you fall within this category of individuals at your organization where your decision-making processes could come into question relative to these old legal standards of fiduciary duty, negligence, and a few others. Now, how do you go about discharging those obligations? One, you make sure that you have all the necessary resources, individual decision makers around you. That includes legal counsel advising you on a daily basis or a routine basis. If you have a security incident, I highly suggest you do not handle it on your own. This development is going to cascade, not immediately, I don't think, but will cascade into the cyber and privacy lens or landscapes very quickly. And we are going to want to pay very careful attention to it with respect to your obligations within an organization and your understanding of those obligations. Here's a quick slide about an officer or director's fiduciary duties. These slides will be available after today's session, and so I'll leave some of them to you to read on your own, and always happy to answer questions offline. But this is an example of regulating security through privacy in some ways. So California says we're going to regulate employee data. We're going to give employees rights with respect to an organization's handling of that data. Now, how do you get to security from here? Well, one of the things we often say is that we don't have a duty to handle sensitive data or personal data other than what's prescribed by law. But statutes like this that are contemplating consumer data, employee data, and now business to business data will further the lens that plaintiffs counsel, the regulators and courts will have on not just the handling of all of that data, but also on the infrastructure that is used to collect, store, and transmit it. And I give you a quick summary of what's going on with respect to the handling of employee data for your perspective, so you can think about how that may impact your security obligations relative to these privacy laws. What do you do? This is nothing of, shouldn't be news to any of you if you work in this space. I'll mention just a few things, and of course, I'm biased as a lawyer, but performing risk and gap assessments without buy-in from the organization and involvement from the organization, especially legal, is a mistake. You absolutely need legal on board to do these assessments so they can understand and then help advise you where the legal risk may materialize as you assess what needs to be prioritized, not just on an operational perspective, but also from that lens, which can be very expensive. A lot of our clients do these assessments with our advice, and so we're working side by side with an assessor, unless it's us providing the assessment. And I think that's something you should contemplate and speak with your lawyer about. There's a number of other things in here where all of this can be handled with counsel at the table, helping protect your decision-making along the way. Establishing a privacy and security-centric culture is nothing new. We give you a couple of ideas here, but having a constant and meaningful conversation with the organization is really important from our perspective. I think all too often people are reading about these risks in the news or the lawsuits in the news, wondering if it affects their organization, but not always understanding their role in helping to protect the organization. You know, the FBI is not coming to solve for this, or anyone else in the US government. They can't, it's not their job. It's your job, along with all the people that you include under the big tent approach of security compliance. I also give you a number of additional slides here that you can think about. And if you're speaking with your legal counsel, use these slides and say, well, this fella, Scott Lashway, mentioned that we should be doing all these things. And if you're not doing them, you should have a very well documented or thought through process to say, you know what, we're not ready to do that today, or we're not capable of doing it, or we don't have to do it. And I'll let all of you kind of work through this because I'm running out of time and I want to answer a couple of your questions. So is there a survey of security done on all states? The answer to that is no, if I'm understanding the question. No. The law that we turn to most for security is New York's Department of Financial Services cyber rule. It applies to any financial services organization or their vendors that are licensed to do business in the state of New York. It's very thorough. It's pretty thoughtfully done, and I would highly encourage you to do it. I'm sorry, to read it. You can find it just by Googling New York State cybersecurity rule, and it'll make complete sense to you. It's written in English. Which of the issues you have discussed today are you seeing land companies in court the most often? Right now, we're seeing the wiretapping cases lead the way, with the biometric litigation second. The other places we see organizations land in court are the mishandling of security incidents. All too often, these incidents happen locally or start small. One person clicked a link, and folks don't always have the utility or the tools available to them to truly assess that risk. We tell our clients repeatedly, please just call us. We're not surgeons. We like to be general practitioners. We're not going to charge you an arm and a leg for a quick phone call to say, hey, here's my sense, you have a live one, or here's my sense, I think you can handle this, and here's what I would do. Build that team now. And if your legal counsel is not willing to do it, force them to do it. If you could offer one piece of advice to cybersecurity leaders with regard to governance trends, what would it be? Where's the biggest focus? Up and down communication within the totem pole of cyber and privacy. Cyber needs to understand privacy, and privacy needs to understand cyber. They both need to understand information technology. Legal needs to be the fourth part of that stool if you have those obligations segregated. And I would include other parts of the organization if they have them, like compliance or audit. They're part of that big tent approach to this as well. But make sure you're reporting actual substance up to the C-suite and then to the board when you're invited. This is a conversation that needs to be a live one and happen routinely. We encourage companies to have cybersecurity committees, even if it's 3 people in a room. Force the discussion on a monthly or quarterly basis so that there's a better understanding of what risk your organization faces, and frankly, what risk you're having to confront. I've had so many occasions where I've said to the CISO, listen, I know you need budget. Let me help you get some. How are you going to do that? We're going to have an honest conversation in the organization about the risks you're having to confront. And the last time I did that, we walked out of the room with initial 7 figures for the CISO to go implement some new technology that was really, really needed. Let me see what other questions we have. For a mid-market company, how large of a D&O insurance policy should you have? That really depends on the potential risk you have in your organization. Now, your D&O policy, you will need to make sure covers cyber risk or privacy risk. There is a very purposeful trend where non-cyber policies are not covering cyber risk these days. And even cyber policies aren't covering all cyber risk. That's been a trend, obviously, for a long time, but it's getting even more limited. Where I was told recently by a senior broker at one of the larger insurance brokers in the world, that most of this new litigation is not getting covered by cyber insurance. The policies just aren't intended to cover the risk. That's why it's helpful to have a lawyer who knows this standing by to help you as you think about, well, should we spend money over here on proactive work, or are we going to spend money on our lawyer at the end of the day trying to clean up, and then we only have to do the proactive work still? is there any best practice, process, or document related to data governance? There are some out there. The NIST framework is my favorite. It's obviously hard to implement. 853 is particularly hard to implement. The government in certain sectors is starting to give credit if you've implemented NIST and you're still popped and have to deal with regulatory fines or penalties. Healthcare being one of them, from the Department of Health and Human Services and their Office of Civil Rights. I would turn to NIST first with respect to, and there is a data management section in NIST, and focus on that. It's very down in the weeds, but from reading that, you will pick up themes and threads that relate to data governance. Simple ones, multi-factor has to be on. Encryption needs to be deployed when moving personal or protected information of any value. So I've run out of time, and I'm going to toss it back to Vicki Lynn. Thank you, everyone. I'm always available to answer more questions offline. And like I said, the slide deck is available from Argyle.
Thank you, Scott. Thank you that was such a information-packed presentation. I appreciate it very, very much. I know our attendees do as well. And I would like to thank everyone for attending today's event and for joining us today for this session. This session, along with all of today's content, will be available on demand following the event. This does officially conclude the Argyle Cybersecurity Solutions CISO Summit. Thank you, all of you, again for joining us and engaging in our content, and have a great rest of your day. Thank you again, Scott.
Thank you.